Do we have any indication as to when the Supreme Court may rule regarding this absurd question of presidential immunity? Because we've already passed some opinion days and we haven't heard anything. So my worry here is that they don't issue an opinion until the last possible moment by design. And of course, the longer we wait, the more of a delay that we have in the DC prosecution.
There's no indication about when they might rule, and you should believe anyone who tells you that an opinion is coming or is going to come on a particular date. Of course, there are some mile markers that we have in mind for the date by which they should probably issue an opinion if there is any hope of a pre-election trial. But other than that, we have no idea about when they might release an opinion. Other than that, by custom, they release opinion in argued cases by the end of June.
Even if we do get a decision at the end of the term, would there still be time then for Judge Chutkan, who's presiding over the DC trial, to schedule that trial before the 2024 election?
I think if they wait until the end of June to release an opinion, that would be really difficult to get a trial scheduled before the election, because Judge Chutkan had indicated she needed 80-some days of pre-trial proceedings. Right, exactly. And so if it's end of June, then 88 kind of pushes it until well into the election and possibly after, whereas if they released it at the end of May, then I think there is some possibility, depending on how they write the opinion, of a pre-election trial.
Well, as if we needed the added anxiety here, isn't it also possible that the Supreme Court could withhold the decision on this case until even the next term, meaning we wouldn't even have a decision by the end of June, which would be the last possible moment in this term?
That's possible, but extremely unlikely. It's very, very, very rare for the court to put off a decision in a case until the following term. Again, by custom, they release all the opinion in argued cases and, by the end of the term, which is, end of June. Now, they've done that in a small handful of cases, but usually under the auspices of requesting additional briefing or adding additional questions from the case. And it was clear from the argument in this case, they were just fine injecting the additional questions right into the case as it was. And so I guess I am not personally expecting them to delay it until the following term.
Okay. I mean, couldn't the argument be made that most of this is not what we expected anyway? I mean, for them to take up this question of presidential immunity for someone who's sitting in the Oval Office and committing criminal acts, that also seems unexpected in terms of them taking up in the first place when there was a perfectly reasonable, airtight justification with the lower courts.
I think, of course, this case is unprecedented and unusual in a lot of ways. Having a former president accused of multiple crimes, including the very serious crime of refusing to leave office and interfering with the peaceful transition of power, is unusual and unprecedented. That being said, I think the Supreme Court taking an important case that presents a novel, unprecedented question about the scope of former presidents' immunities from crimes after they leave office is not unusual. I think what is very concerning is that they waited to take this case until the last possible moment, rather than taking up Special Counsel Jack Smith's invitation to do so much earlier, like in December, before the DC Circuit had ruled. But again, I don't know that signals that they would put off the decision until the following term rather than just delaying until the end of this term.
So moving over to Florida, we have Judge Cannon, who had already interfered on Trump's behalf, which led to her being rebuked by the 11th Circuit. That was in the early days of this trial. She then had this insane idea that she would take seriously Donald Trump's Presidential Records Act claims, which were completely baseless. And now she's indefinitely delayed the trial, even though Donald Trump's own team had requested an August trial date. And that was kind of blown by Judge Cannon. How does Jack Smith not have a predicate to seek her removal from this case?
I think the reality is that seeking a judge's removal is an exceptionally high bar, and it's an exceptionally high bar in general. And when you're dealing with matters like scheduling, that is an area where Court of Appeals give trial judges a pretty maximum amount of deference, just because they are balancing between different cases. And so it's difficult to assess a judge's treatment of one case given the rest of their docket. And so Special Counsel Jack Smith, asking her to be removed on the basis of a scheduling decision is just so difficult that I don't see him doing that, even though I think her conduct has just been appalling.
Is there any worry that, take the Presidential Records Act thing, but for example, where she would have been able to instruct the jury based on something that doesn't have any basis in reality? I mean, her allowing for that in the first place, is that unto itself, allowing jeopardy to attach and then giving the jury these instructions that would have allowed them to kind of throw away this entire case, is that alone not enough of a predicate for Jack Smith to seek her removal?
Usually a judge making a bad legal ruling is not by itself sufficient to ask for a judge's removal. It's not uncommon for judges to be reversed, and even if they are reversed multiple times, that is not a sufficient basis for a judge's removal. And I think what people see in this case is a judge making absolutely outlandish legal rulings and then making the very reasonable inference that the judge is doing so in order to benefit, one of the parties in the case, for political partisan reasons. And the unfortunate reality is that other judges are extremely, extremely hesitant to basically conclude that another judge is acting in bad faith. And so special counsel Jack Smith has, very reasonable inferences, but without something explicit in the record, he risks, again, losing his own credibility by making that allegation. And I think he's just in a really difficult position, particularly while this appeal is pending in the Supreme Court, and he might be banking on, again, asking the district court to make a quick ruling to allow an actual pre-election trial to happen. And so it's really tough.
Taking a step back, like 30,000-foot view here, is there recourse in the legal system for a judge like, for example, Aileen Cannon, who so egregiously flouts her duties, or is it just like lifetime position and that's that?
I mean, there are political checks in the system. Those political checks are supposed to be impeachment, or short of impeachment, Congress doing things to actually control court's docket. Like, for example, confirming judges to the district where Judge Cannon sits so that a lot of cases are not assigned to her. But those political checks are failing, in part because Republican senators are obstructing Joe Biden's ability to confirm nominees to states that have 2 Republican senators, and in part because, Congress is hamstrung by the filibuster and is unwilling to do things like expanding the number of judges in a particular district or court of appeals, or shrinking the court's docket when judges behave in these outlandish ways.
Can you expand on that just a little bit more about this whole idea of blue slips in a state like Florida, for example, that has 2 Republican senators?
Yes, exactly. So by convention, there is a blue slip tradition by which presidents wait for the home state senators to return what are called blue slips on the judges who are nominated to district courts in that state. And Joe Biden has said he will adhere to that tradition, even though it seems very clearly like Republican senators are abusing it and essentially withholding consent to any plausible district court nominees in their home states, and thereby holding open vacancies to allow Republican presidents to fill them, to stack the courts in red states with extreme Republican nominees who will sign off on outlandish, extreme Republican policies. And that makes it difficult to bring cases in jurisdictions like Florida.
Do you think that that's kind of an instance of naivety for Democrats to continue to adhere to these traditions that are clearly not being adhered to by Republicans? I mean, I don't think Donald Trump was a big stickler for making sure that we adhere to blue slip traditions.
Well, Democratic senators weren't abusing the blue slip tradition. They were returning blue slips on district court nominees in Donald Trump. I mean, you had multiple Democratic senators voting to confirm Aileen Cannon in a lame duck session. So yes, Democrats are being naive, particularly in continuing to adhere to the blue slip tradition when their Republican counterparts are not returning the favor and acting in similarly good faith and being willing to confirm nominees of the other presidential administration.
Moving over to Fulton County, Georgia, we have some unwelcome news there. The Georgia Court of Appeals has agreed to review Judge McAfee's decision to allow Fani Willis to remain on that Fulton County case. If Judge McAfee's decision here was not only proper, but actually he took extra steps to protect this case. He had Nathan Wade, who Fani Willis had an affair with, he had him leave the case, or he gave them the option of one or the other to leave the case. Nathan Wade left. Then why would the Georgia Court of Appeals even take this issue up?
Again, I think the reality is in these very high-profile, extremely salient cases, appellate courts, whether it's the Georgia Court of Appeals or the U.S. Supreme Court, feel the need to intervene to make sure, that they have the final say on all of the legal issues that are arising in the context of the cases. Prosecutors are held to high standards. They should be held to high standards. But the reality is the legal system is not set up for this kind of quick process, and that is gumming up the works and making it quite difficult to hold a former president accountable for, again, attempted election interference while they are attempting to, run for that same office again.
Right. It's kind of counterintuitive because this is the system working as it should with all of the checks in place to make sure that we have airtight decisions. But at the same time, it pretty much hands Donald Trump the delay that he's seeking just by virtue of going through that process.
Exactly. And it's a very frustrating system where you see someone like Donald Trump, who has zero respect for the rule of law and legal processes, being able to, I think in some instances, abuse that system, like filing all the motions before Aileen Cannon, many of which were frivolous and silly, but then allowing that to delay the process. And then in other instances, again, courts feeling the need to, I think Fani Willis and Nathan Wade made a poor judgment call. I don't think that required Fani Willis's disqualification, but giving, some basis for litigants and courts to say, we need to review this to make sure all of the I's are dotted and the T's are crossed. Like, that was a bad judgment call, and we are unfortunately bearing the costs and consequences of that.
Finally, moving over to the New York criminal trial, maybe an inkling of a bright light here. How do you feel about the progress of this case so far?
I have to say Stormy Daniels' testimony was way more damning for the defendant, than I, at least personally, had been anticipating. I think she testified about a few things that are really important to the ultimate determination about whether Donald Trump is guilty of the crimes he is charged, but also expand upon the narrative about what exactly was going on. So on specific details, she gave several instances where it was clear he didn't care that his, sexual relationship with her got out, before he was running for office, thereby suggesting that in fact they were, concealing the relationship once he became a candidate in order to have to avoid disclosing it for political reasons. And that's part of the basis for the felony charges here. And then second, hearing her describe the personal context and situation she found herself in, where she was so uncomfortable and did not feel like she could say no and just went along with this guy. And this guy is the person who directly facilitated women losing their reproductive freedom and bodily autonomy. And this was, again, the possibility that that would be disclosed in the midst of the Access Hollywood tape, when people were raising alarm bells that Donald Trump would be the person who would appoint justices to overrule Roe and again strip women of their bodily autonomy, when he is talking about women this way and making women feel this way and forcing anyways, I found it very powerful and really strengthened the prosecution's case.
Well, all the while, Trump's whole defense in this is that he never even had any encounter with Stormy Daniels. And so wouldn't that suggest then that Stormy Daniels is just taking the stand on a daily basis and just perjuring herself over and over and over? So the jury could either believe that Donald Trump is telling the truth and Stormy Daniels is just continuing to perjure herself, which unto itself is a felony, or the guy who won't even take the stand himself is the person who's in fact lying.
Yes, of course, right? The willingness of someone to take the stand and testify to this and be able to provide details about the instances, about the events that they are testifying to, all of that, you're right. Again, vastly undermines, the supposed defense that we may never hear about because, unclear whether he's going to take the stand and what we will hear about.
But at the same time, the fact that he isn't taking the stand, isn't it true that the jury can't infer a negative inference from that? And so they can't even, you can't even look at the fact that he's not taking the stand and draw anything from that.
They cannot infer from a defendant's failure to testify that the defendant is guilty. But what the jury can do is weigh the evidence. And if the only evidence they have is Stormy Daniels saying this happened and the defense side not really undermining her credibility, but in many respects bolstering it, then that's all the jury has to go off of.
Well, in this case, the New York Times actually put together a really helpful list of where all the jurors got their news, and it's juror number 2 who gets their news exclusively based on the questioning from Truth Social and from X. So not an ideal media diet if you're looking for someone to give an objective sense of what's happening in the world. But are you worried about a sleeper Trump fan on the jury?
Of course, right? Of course, we should always be worried about people who are fed misinformation and live off of information and refuse to process facts in this day and age, because we have seen evidence of that. Now, I will hold out the possibility that people will listen to charges that they receive and when faced with actual evidence can acknowledge the facts before them and come to a reasonable conclusion. But of course, we can't rule out that possibility.
Why do you think that the prosecutors would allow a juror like that to remain on this case? Like, why not just cross all your T's and dot all your I's and just not even allow for the possibility that okay, like maybe this person answered questions appropriately enough to stay on the jury, but why not just make sure that we didn't fall into this position anyway?
Right. So I think you're referring to the prospect that both the prosecution and the defense had the opportunity to strike jurors for any reason whatsoever, as long as they are not removing them. Right. As long as they're not removing them for illegal reasons, like on the basis of race or sex or things like that. So I don't know, which possible jurors the prosecution exercised their strikes on, or what other jurors they were looking at, and so it's a little bit difficult for me to assess whether they should have struck that person in particular. But I do agree that it is a real risk based on those answers.
We've just spoken about all of the prosecutions that Trump is contending with right now. A lot of it is giving a lot of people around the country a lot of worry, because we see judges like of course Alito and Thomas on the Supreme Court, Judge Cannon in D.C. how do you retain faith more broadly in a judicial system that more and more is exposing itself not as this high-minded branch of government that kind of rests above the fray of politics, but rather is little more than, just the Marjorie Taylor Greenes of the world in a robe?
I mean, I guess I don't think the solution is just to retain faith in a system and indulge in a fantasy. I think the solution is to fight for the system that you want. And we are being reminded every day of the stakes of Donald Trump's judicial appointments. The behavior of Eileen Cannon, of Sam Alito, of Clarence Thomas, and so many others, should remind us the stakes of every single election, at the state, local, and federal level. And we should fight and vote for the justice system that we want and we deserve.
Right, that's a great point. In fact, all of the cases that are giving everybody so much anxiety right now are actually the direct result of him based on the people who he's appointed. I mean, you look at Roe, that wouldn't have happened without those 3 justices that Trump himself appointed. You look at Judge Cannon, Donald Trump appointed her. You look at, the fact that there's a 6-3 conservative court is why this question of presidential immunity was taken up in the first place. So we have a direct link right back to the person who right now is running. I mean, we have I wouldn't call it a privilege of being able to vote, but like the privilege of being able to vote against him in this election and seeing the consequences of what his first election brought onto this country.
Yes, exactly. That's what I tell myself and what I try to talk to people about.
Now, are there any other court cases other than these Trump trials that you're watching particularly closely right now?
There are many. I would just mention one, which is the case about emergency medical care for women who go to hospitals with pregnancy complications. And doctors and hospitals believe that if they are denied an abortion, they stand the chance of losing a bodily organ or a major bodily function and potentially their life. And the Supreme Court is deciding a case about whether states can prohibit hospitals from denying women, pregnant people, abortions under those circumstances. The Biden administration is arguing that an important federal law, the Emergency Medical Treatment and Active Labor Act, prohibits hospitals and prohibits states from prohibiting hospitals from denying women life-saving and health-saving abortions. And the Supreme Court is going to decide that question. So basically 2 years in the wake of Dobbs, we are faced with this question about whether states can essentially force women to lose organs if that is the cost of denying them abortions.